State whenever you're ready.
Thank you, Your Honor. May it please the court?
Yes, sir, of course.
Counsel. Ladies and gentlemen. Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. In 1770, the second president of the United States, who was a lawyer at the time, said those words, John Adams. He stood in a courthouse not like this one, not with air conditioning, not with our comfortable seats, and stood up for hours in front of a jury of people. And he said that. One of our greatest founding fathers, who helped wrestle with and create our founding documents, as this court so eloquently said right after we picked a jury, to this day, we're still adhering to that great document called the Constitution, written in 1787. Facts are stubborn things. Here's a fact. The defendant confessed 3 times to killing Ione. That's a fact. And what's even a more important fact to note is the similarities between those statements of gentlemen that do not know each other. Joseph, who lives in New York, gave consistent facts about what happened. They go point out one. Oh, well, she's wrapped in carpet versus she's put in bags. All say she shot. All say she shot at Ace. All say he summoned her there somehow. All say she's pregnant. All say he wanted that baby dead. The consistency of those 3 consistent confessions should make me sit down right now and give you this case and stop insulting your intelligence. Because those 3 facts, to match like they did, of 3 gentlemen that do not know each other, have never discussed anything before. One's in jail. These other 2 guys, Maurice and George Jackson, on a wire. And some man in New York who's the defendant's brother never confers, ever. Those 3 confessions mesh. That's a fact. And it's stubborn. And it's hard to argue around, but you just heard it. Counsel gets up here and says, well, there's holes in the state's case. The only holes came from this man right here. Those hands right there, he scooped up dirt or covered up dirt. Wrapped her up. Whether it's a carpet or whether it's 2 bags, doesn't matter. We don't have to prove that. He told all 3 of them he put her in a dumpster at work. And they just happened to get that right? That's just happenstance? Don't let the defendant get away with holes that he created. He tried to get rid of the body. He tried to get rid of the blood. He tried to go shoot his gun. Make it look like he shot it recently. You know, he couldn't kill her anywhere else. You know why? Because his wife and him share their location. if he goes running off way out on the west side or out to Bayard or out to wherever and dumps her somewhere, she said, we share our data. And guess when his is off? Guess when his cell phone is off? Guess when he leaves work? Guess when this happens? Guess when he lures her from Terry Parker? It lines up with the cell phone data. It lines up with her data. She has no communication whatsoever. She leaves Terry Parker at 11:05 a.m. Guess when he leaves his work? 11:15. They could come up here and argue, well, he ran an errand at work. That's a 25-minute ride. Where are the other extra 53 minutes? That's why we had Detective Abbott testify to that, to show he most certainly had time to go meet with her. But the defendant, he made a grave mistake. Even though he tried to clean up, even though he tried to get rid of evidence, even though he tried to get rid of the body, even though the Dong Quay is on his wife's account. By the way, it doesn't, listen, if the girls got on the mother's account, which they did not, there's no evidence of that, okay? If those girls got onto that account, where'd they get that idea? The Snapchat alone tells you there's a lot of sex going on between the defendant and IS under everybody's nose, but he's the one sneaking around doing that with IS. It's a horrible secret to put on a 14 and 15-year-old child. It's despicable. Despite that, despite all the Snapchat messages that he chooses to communicate with them on, that automatically deletes. But he doesn't talk to his wife that way. He talks to the nieces that way, both IS and SS. And oh yeah, now he's taking a run at another niece, ID. Guess how he spoke to her? Snapchat. He knows how to delete evidence. But he made a grave mistake. He ran his mouth, and he told his brother. Facts are stubborn things. And that brother sat here yesterday, and he, the defendant, put him in a horrible position, just like he did with SS and IS. But you can say all day long, as counsel just tried, well, he didn't really believe him. He picked that phone up and called the police. He said, and I'm sure you heard it from that witness stand, when he is, when I'm around him, he's confident. He's himself. And on this call, he's panicking. He's frantic. Why? Well, then out comes what he tells them. I got this girl, she's pregnant, she's my niece. I don't know what to do. I tried to strangle her, I can't stomach it. She's back in the car. By the way, they asked the defense, that doesn't make any sense. It doesn't? Newsflash, folks. When you strangle somebody, they can pass out. You strangle a little girl, sign for that man, he can pass out in a car. And he calls his brother back on the same day. I took care of it. Those are chilling words. He calls his blood brother and says, I took care of it. After just telling him.
Judge, I like when a prosecutor or a defense attorney in their closing has like a line that they continually go back to and relate to the evidence. And he says, facts are stubborn things. I like that.
Yes, and that's what they teach us in trial skills, right? Is you need to have the themes, you need to have all of that in your argument. I think it's wise. I think he's very emphatic with his messaging, very passionate for this jury. All right, we're going to hit the pause button. Of course, we'll pick it up with the state's rebuttal right on the other side of this short break.
Tonight on Closing Arguments, an in-depth profile of the accused killer in the Delphi murder case. What we know about Richard Allen and what his defense team is now saying about the investigation. And the civil trial begins today in the case at the center of the popular Netflix documentary, Take Care of Maya. We'll bring you the biggest moments from opening statements as this trial gets underway.
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Ashley Wilcott with Michael Ayala, bringing you the case where a Florida man faces the death penalty if convicted of killing his pregnant teenage niece.
Prosecutors say 38-year-old Johnathan Quiles murdered and hid the body of 16-year-old Ayanna Sawyer back in 2018 after finding out she was allegedly pregnant with his child.
His defense, however, says Quiles is not the father and claims that Sawyer may still be alive. After all, her body has never been found.
All right, right now I want to take everyone back to court for more of the state's rebuttal argument.
That alone convicts him. That fact is so stubborn, when you add that the second confession, the wire comes along and matches it almost perfectly. Almost perfectly. You're having sex with your niece? Remember that one? Well, yeah, what about your wife? Well, yeah, she's pregnant and the doctors say she's high risk so we can't have sex anymore. We even know why he's having sex with SS and IS. We know why. He got her pregnant. It's all over the wire. Your ears got to... Listen, we apologize for the language and the things that you had to hear. Your ears heard some chilling words about right out of his mouth describing how he killed that little girl. And talk of the facts, almost like everything that you see here, they talked about. Landfill, she's pregnant. Listen, DNA in the underwear. Facts are stubborn things. We don't even have to prove motive, ladies and gentlemen, but we sure did. He could not let that baby be born. And he was determined to make sure that Hazel did it. As he said on the wire, I think it's a girl or something. That little girl's a human being. She had a name. And he killed her. Now, we're talking about puzzles a lot. My boys were little. We bought an alphabet train. The alphabet train was something it came really two ways. You have it in a puzzle, but they also had little cars that connected together. And little wheels on them. But they were these little shapes, they were like about that big, and they were in the shape of the letter. And you would connect them to learn your alphabet. You'd line it up on the floor. My boys did. That's how you taught them the alphabet. And each one of these had shapes on them. They had the shape of themselves, whether it was an A or a B or an H. What we just did for you is lay out all those alphabet pieces. We're asking you to put them together. What Miss Michelle just did is she took an individual letter and said, well, I'm going to take this I out and I'm going to hold it up and say, well, couldn't it be a 1? Or I'm going to take the W out and I'm going to turn it over, flip it over, show it to you. Go, well, it could also be an M. Isn't that possible? How many times did you hear that question from counsel on cross-examination of all the state witnesses. Well, isn't it possible that? Isn't it possible this? Isn't it possible that? Isn't it possible? Isn't it possible? Isn't it possible? Do you know what reasonable doubt is? It is not a possible or speculative doubt. Then why ask those questions? The counsel comes up and says, well, there's no DNA that connects the defendant to this. Did she just say that to you? Are you kidding? What in the world is his DNA doing on the inside of you? I don't care if that's spit, saliva, semen, touch DNA. It has no business being on the most intimate, private areas of a 15-year-old little girl's underwear in March of 2018. This alone tells you what's going on. We spent, I don't know how much time asking whether this particular DNA was, well, do you know whether it's sperm? And he said, the expert said, well, it's a sperm cell fraction. I don't care what it is. What he was certain about was that it was the defendant's DNA on the interior. You hear what he said? A yellowish stain? Now, come on. It wasn't enough. Tell us whether it was a sperm cell or a blood cell or a saliva cell. That does not matter. That's trying to create possible doubt. And that is not reasonable doubt. And Nicholas Kotu, he explained it. He says, listen, he goes, it's just not enough to call one way or the other. And he spent all this time on it. And he says, listen, it was a sperm cell fraction. That's what he said. But setting all that aside, what the defense just did with that DNA is they held it up and go, well, it's not really a Z in the alphabet. If you pick it up, pull it out, turn it on its side, it's now an N. That's not what your job is. Your job is to take all of this evidence, put it together, and render a true and just verdict. Ladies and gentlemen, that evidence right there is the most inculpatory piece of evidence that exists on the face of the earth. And it existed in a place, the last place a 33-year-old man's DNA should be is in a 15-year-old girl's underwear. And then they bring up, well, the Snapchat. Counsel says, well, it's only half the way the records came in. We got half the conversation. Listen, you can read it 100 times, and there's no other conclusion. We were asked, and we made it clear, please use your common sense. You can't read those Snapchat messages and draw any other conclusion rather than it was between this defendant right there. No other way to read it. Names.
All right, still with us, retired Police Sergeant Melissa Pinkleton. Melissa, you know, as I mentioned earlier to Judge Ashley here, I thought that line of facts are stubborn things is a really good way to go about this, to give a theme to these jurors. And I can honestly see a juror in the jury room, maybe coming across another juror who doesn't quite buy into the guilty verdict and saying, facts are stubborn things, and going through the facts. So I think it's a really good thing. Your take on that?
I think it's a really, really smart strategy and a way to phrase it and then start adding into the factual things that they have that are stubborn. And I think they may be successful if there's some jurors that are on the fence. I think this may be a successful way with the facts are stubborn things and maybe turning them around if they were on the fence before, maybe getting them on their side. I will say, though, looking at the totality of the case, I'm not so certain that this is a slam dunk. If you look at the totality of all of it, I don't believe it's a slam dunk. Did he most likely do it? Yes, I truly believe that he most likely did it. But I do think that this is not going to be a very quick, 1 hour deliberation and it's completely done. He's guilty. I think there's going to be a lot of conversations that are going to be had in that jury deliberation room.
Yeah, the only problem I have, and I agree with you, I think there's certainly enough on both sides where conversations could be had, but Judge, the problem is to be a juror on his side is going to be a very unpopular place to be. You're not going to want to stand on his side because I think it's fair to say we know he did some really unsavory things.
He did, and the sexual battery I think is a no-brainer based on the evidence, and they'll do that. But I have to say, I have seen jury time and time again, and I'm sure you have as well, Michael, where they do go back and they make the unpopular decision.
Fair enough.
Death penalty, right? Let's talk about that for Nicholas Cruz. What did he not get? The death penalty, because they take their job very seriously. They look at the evidence. I too, Melissa, feel like, okay, I think he did it, but if you look at the evidence, are they going to convict him? But the thing I really held on to that this prosecutor just said was, the defense has created possible doubt. And that is not the same as reasonable doubt, because really there's no other explanation based on the evidence that's reasonable. I think that might convince a jury to find him guilty.
That absolutely could. I mean, you make an excellent point, and that could. And I think really the only way that we're going to know, and like you said, anyone who is on, quote, his side, that's not going to be a popular place to be on. I think we all know this is a bad dude who did a bad thing, and I think it's not going to be the popular side to be on. So it's just going to come down to how strongly people feel and how strongly they convey their feelings when it comes to the end of this verdict, when it comes to the final vote. That's what it's going to come down to. So it's going to be interesting, but I really don't think it's a slam dunk. I think that we're not going to be sitting here in an hour with the verdict, because it's just not that simple.
All right, fair enough. And you know, I agree. This could take some time, but I also think it's going to rely a lot on the charge to the jury and how they hear what their job is.
Yes.
How they hear it, how they take that in, and they go in that room.
And the definitions.
And the definitions that are given to them. So many of these cases do sort of, you know, they're grounded in that.
I
so
agree.
I think that's important here as well. All right, Melissa, stand by. I'm going to take a break here, folks. Coming up, prosecutors urge jurors to use their common sense. More of the state's rebuttal still ahead. You're watching Court TV, our front row seat to justice.
I've worked hard all my life. I've gone from being a local reporter to becoming a law student to then even going on to teach other lawyers, all before I came to Court TV. As a journalist, lawyer, and teacher, I learned the secret to success is speaking in your authentic voice. And I bring that lesson to my show, Opening Statements, every morning on Court TV.
Opening Statements with Julie Grant. Weekday mornings at 8, 7 Central. Only on Court TV.
A quick programming note before we take you back into court. Tonight on Closing Arguments, we'll turn to Utah and the child abuse case against the so-called momfluencer Ruby Franke. According to new search warrants, her son told investigators he was tied up so tight that it left rope burns, which were then treated with a mixture of honey and cayenne pepper.
Now remember, the boy escaped through a window last month, then ran to a neighbor's house begging for food. It allegedly happened at the home of Franke's business partner.
So what else did officers find in that home? Tune in tonight to Closing Arguments as our own Vinnie Politan sifts through the search warrants. That's at 8 p.m. Eastern tonight.
All right, back now to the pregnant niece murder trial. 38-year-old Johnathan Quiles faces the death penalty for the presumed deaths of Ayanna Sawyer and her unborn child.
Prosecutors say he killed his niece to prevent anyone from learning he was the baby's father, but Ayanna's body was never found. The defense says there's no proof that she's even dead. Let's pick it back up with the state's rebuttal.
Your aunt, he uses one time about the whole kiss goodnight. Oh, well, kiss you goodnight. I'm in your house. It's clear. If that's not who this is, then this defendant and IS have an exact similar scenario going on at some other house somewhere else, and there's some other girl named Naya and Maya and Ayanna. Folks, that makes no sense. None. And then counsel makes a big deal about, well, you know, Naomi asked him, hey, what are you doing? You know, I'm on Snapchat. And she says, well, it's no secret. Well, you know what she didn't do? She didn't go over there and say, listen, husband, let me look at your phone and make sure that's what you're doing. She didn't do that, ever. Then they argue, well, yeah, there's no body, there's no blood, and all the... Listen, we established she does not exist on the face of the earth, and we know it took a long time. And we greatly, greatly appreciate your patience. You all have been, as the court said repeatedly, your attention has been unbelievable. Your promptness, your attentiveness. But let me make this perfectly clear, we had to do that. In homicide cases, usually body laying there. Okay? This is a homicide case. We had to establish the body doesn't exist. And we did that. Not one shred of existence. Counsel can get up here all she wants. Says, well, there's more charges on that account. Go look at them. Did you remember what they said in the opening statement? Well, she went to Wendy's that day. She went to Wendy's that day. Mr. Davis sat right here and said to you in opening statement, remember what lawyers say, that's not evidence. When I had the custodian on the stand, tell me about that Wendy's trip. Oh, no, that wasn't December 19th. Look in the body of the transaction. It's December 13th. It was posted on the 19th. Why are they up here saying that to you? Reasonable doubt is not a forced doubt. Then why say it? They got the same records we do. Why come in here and ask questions about this Wendy's? Oh, no, that wasn't on the 19th. She made that perfectly clear. Then they make, well, there's no blood. We talked about that. He got rid of that. There's no murder weapon. Yes, there is. Yes, there most certainly is. Why? Number one, because he said so, not once, not twice, but 3 times he said so. Here's my gun. He even talks about it extensively on the wire. Yeah, the police hadn't even gone and got it yet. They start laughing about it. Are you kidding? This girl is thrown to trash, and he's laughing about the police hadn't even gone and got the gun yet. Counsel in the opening statement, they just argued it again. Oh, the state's assuming this happened at Ace. The state's trying to make this into their crime scene. The state's not doing any such of a thing. The state pressed play on a wire, and that's what he said. That's what their client said. He said it to Joseph. He said it to Damian Hatch. Are you kidding? Is the state just sitting over here, we're just dreaming stuff up? He said it. And they have, the state's assuming Ace is the scene. Really? I killed her at work over off in a remote area over there. Put her in bags. Put her in the trash. But they take this video and they say, oh, well, you know, if we're taking the B out of the alphabet. We're holding it up going from afar. It kind of looks like an 8. Right?
Thank you to Melissa Pinkleton for joining us this hour.
Still ahead, the prosecutor quotes not John Adams, but John Wayne in his closing remarks when we come back. This is Court TV, your front row seat to justice.
The defendant confessed 3 times to killing Iona. That's a fact. And what's even a more important fact to note is the similarities between those statements of gentlemen that do not know each other. All say she shot at Ace. All say he summoned her there somehow. All say she's pregnant. All say he wanted that baby dead. The consistency of those 3 consistent confessions should make me sit down right now and give you this case.
Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. We are in continuing coverage in the pregnant niece murder trial. Johnathan Quiles is accused of killing his 16-year-old niece, who was allegedly pregnant with his child.
Closing arguments are still underway. The state is in the middle of its rebuttal argument. Let's get you back into court for more of that argument.
Holding them up to you and say, well, this isn't really a number one. It's not really a letter I, it's a number one. Are you kidding? Three different times, I killed her at work. And they're telling you, they're assuming where he killed her was an ace. Use your common sense. Now they bring up this red minivan and they say, well, there's no evidence in it. You know, the state, what else is he supposed to sell? All his wife asked Naomi Mobley said at the time, I said, we got too many cars in the driveway. You pick which one. And he sells the one that you see he goes to work in every day. He sells that one. And I got news, you can sell a broken down car. What do you think Ace pick-apart is? What do you think car lots are? What do you think junkyards are? You can sell that other Dodge. He picks the one that was used in getting that girl Ace pick-apart. And shortly, she said, she told him that like mid-December. It was sold in like 8-9 days. Got rid of that pretty quick. And then counsel argues about that. Well, what else? What else can he sell for money? Broken down cars you can get. That wasn't even the issue. You heard Naomi under oath say, "No, I just wanted too many cars out there. Our driveway was looking like a junkyard." And she really took a lot of time picking on IS in her testimony. Ladies and gentlemen, let me make this perfectly clear here. For the defendant to put a 14-year-old girl in the situation he put her in is despicable. The weight that was on that little girl's shoulder, she knew what was going on. She's not going to tell. Then she says, oh, Naomi pulled them both aside and said, is anything going on? The defense wants you to believe that both these little girls go, yeah, we're having sex with your husband. Are you kidding me? Is that realistic? Or again, are they trying to force doubt on you and create this forced doubt? You bet those little girls carried around a horrible secret. It put them in a situation that no 14-year-old knows how to handle. And she says, well, once she figured out that she didn't make it to her grandma's, why didn't you tell SS? Folks, again, the answer is very simple. She's carrying around a secret that's like, oh my God, if I tell, I'm going to lose my sister's friendship. She's got to be run off with him. Maybe he's got her in a hotel. Who knows? There's so many ways for a 14-year-old to interpret that. Oh my gosh, imagine that SS's position that she was in. SS is saying to herself, if I tell, I'm going to forever lose my relationship with my sister. And she's missing, oh, please come home, please come home, please come home, please come home. It's a horrible position that he created. He did this. Now they want to come in and go, SS should have disclosed this quicker. Easy for them. Then we hear, I think they took a shot at Dr. Atchu. They said, well, she's looking down at the floor. She looked concerned. I think there was testimony she wasn't talking. If she wouldn't make eye contact, Dr. Atchu's the one that confirmed the pregnancy. Listen to this. You know what Dr. Atchu said? 22 weeks, 5 days pregnant. That's huge. Why? 22 weeks and 5 days backwards of December 13th, which is the date of the appointment, was July 7, 2018. Do you know what July 7, 2018? There was a family get-together. When they came back from, do you remember way last week? The two little girls went to spend time with Grandma Nancy Ware up in Columbus, Georgia, come back. SS goes home. IS on that night, for 2 nights, went to spend the night with him. Wow. That's why the family blew up in early December 18. They figured it out. Then they up here criticize Miss Michelle says, well, you know, these aunt, grandmother, I don't like the way he hugged her. I don't like the way he looked at her. Oh, they didn't do anything? Well, first of all, it's not a crime, okay, to give somebody an inappropriate hug. And it's also, I don't like the way he looks at her. That was an aunt and a grandmother. You remember those? And both said, counsel just argued to you, by the way, they didn't do anything about it. Yes, they did. The grandmother went to Pam and said, don't let him around the nieces anymore. You remember that? Those are little details that over the week and a half that you've been here, you may forget. Remember, they did do something. And number 2, don't ever question a grandmother's intuition. I learned that a long time ago. The grandmother walks out to a backyard at a family function, and it's just the two of them, the defendant and IS, and he's startled, he pulls away, and it made that grandmother concerned enough to go tell Pam, not about the hug, but hey, listen, you probably want to keep him away from the girls. You need to give permission if he comes over, and you need to be watching out. They did do something about it. They just tried arguing to you that they didn't, and they did. Forcing doubt. Don't forget the timesheet. This timesheet up here with the defendant, listen, he leaves for an hour and 13 whatever minutes. He doesn't clock out. And you can say, well, it's the parts run to the store, whatever. What about those 53 minutes? Another. He knew what he was going to do. Told his brother he'd been planning it for months. He knew what he was going to do. He blended in at work. Violated company policy, as I asked both the Lindroses. If he leaves for a long period of time on a personal issue and leaves and doesn't clock out, is that allowed? That is not allowed. I think they made a couple more arguments about, well, you can't ever see IS on the cameras at A's. Of course not. Of course not. What is the expectation that, listen, well, he's going to put her on his arm and just go walking through his work with his 50-year-old girl? Are you kidding? 16-year-old girl by that time? Of course not. You bet she's not on the cameras. But what does he say on the wire? Them cameras are crappy. You heard it. George Jackson. Yeah, it's crappy camera systems. I know where the cameras don't show. They really argued to you also about the landfill and the clothing. I was just touching on this briefly. But listen, you know, when the detective, who's got, I don't know, 30 years of experience, Detective Shannon Lillard, she's worked major crimes, homicide, crime scene unit detective. When she says, look, I was out there every day. I know what I saw. They want to throw, well, Goodwill dumps there. Got to be other clothes, right? No. Yeah, so what? Ed Schmalfeld said that there's Goodwills there. That doesn't necessarily mean that the area that they were checking had clothes. And by the way, these clothes, isn't it odd? Forget the fact that it's Victoria's Secret that Mom says, yeah, that's hers. Forget that. It's found in the same isolated area. It's a big area, don't get me wrong, but the same area that the engineer, Ed Schmalfeld, says, this is where you need to search if that's when that truck came here. 20 feet down, these 2-3 acres. What's in that 20 feet down, 23 acres? More Victoria's Secret underwear. By the way, it's not in bad shape. Okay, people don't just throw that. It's expensive. People don't just throw that out. And isn't it odd that it's there near a Terry Parker book? Oh, don't forget this. This is the trashiest of trash. Ace pick-apart paperwork in the same area. What in the world is Ace paperwork doing near a Terry Parker book, near clothing as Victoria's Secret items? What is that stuff doing there? And they keep saying, no evidence, no evidence, no evidence. This is evidence, this is evidence, this is evidence. Yes, Ace pick-apart dumpster was dumped there because you see stuff like that. We also know this little girl packed a whole bunch of Victoria's Secret stuff. We know that's missing from a room. We know that. That's there. Does it have to be the same size? So she grabbed a pair of her mom's or her sister's or whatever. Doesn't matter the size. It doesn't matter the size. There's a Terry Parker book there. What's that Terry Parker? Of the 50 or 60 schools in Duval County, the Terry Parker book is there. Folks, all this evidence screams at you. It screams who did this. The circumstances show who did this. The evidence, the phone, the Snapchats, and I haven't even mentioned the wire in this statement, or the statement to his brother. The circumstances alone show who's in trouble. He got his little niece pregnant. The motive is there. Then they call Kamar Humphrey, right? They call Kamar. Well, we didn't get along in the depot. That was clear, right? And then he says, I lied to you. Then I come up and I'm like, wait, you lied to her. You weren't getting along with her. But I'll tell you what, did you get on the news? They didn't bring it up. The defense didn't bring it up. We did on cross. Didn't you get on the news pleading for the public to come forward with information about this girl? Yeah, yes, sir, I did. And they call him. Now that wire, we're not going to look through all this. Let me just make this very clear about the wire. There is only one conclusion to draw from listening to it in its entirety. We apologize, 2 hours, but you had to hear it. It is littered. It is.
We need to take a quick break right now. When we return, we'll get you back to the state's rebuttal. Stay here with us on Court TV, your front row seat to justice.
Tonight on Closing Arguments, an in-depth profile of the accused killer in the Delphi murder case. What we know about Richard Allen and what his defense team is now saying about the investigation. And the civil trial begins today in the case at the center of the popular Netflix documentary, Take Care of Maya. We'll bring you the biggest moments from opening statements as this trial gets underway.
Closing Arguments with Vinnie Politan tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. Michael Ayala here with Judge Ashley Wilcott. Now, the state is close to wrapping up its rebuttal in the pregnant niece murder trial. Now, after that, the jury will get the case.
And we want to get you right back into court. Of course, we hit the pause button. The prosecutor, Daniel Skinner, continues his final rebuttal argument.
Filled with incriminating statements that lead to one conclusion. Here's a couple examples. Man, if the body's dumped with book bag and stuff, then it's easier to find the defendant. No, it was all separate. This is straight from the defendant. When my wife got pregnant, she's so high risk, they cut us off from sex. Why not get rid of your gun? That's in there. You heard it yesterday. Well, it's registered to me, but that's all taken care of. I took it and shot it at the gun range to blow off steam. Didn't need to blow off steam that much because, as his wife said, he slept like a baby after she disappeared. Whole family's in a tizzy, and he's curled up sleeping like a baby. That's offensive. So he went and blew off steam. Why? Thought he got away with it. Boy, that pressure was coming down. You see it in those Snapchat texts. Oh, you see it. A man talking to a little girl like that. Manipulative. Then on the wire, man, you cleaned it all up. And that's what he said. Yeah, I even went to the range that day. Man, did you kill her one day and dump her the next? Yeah. Man, did you made her sit in a car when she got shot? No, she wasn't in no car. How long she been dead? Well, you know, the heat index, he went into his little Discovery Channel explanation. You remember that? He said, she's been cooking out there. She's been cooking. That little girl is laying up dead in that dump somewhere. And that's the words that come out of his mouth. She's been cooking out there. Man, where'd y'all have sex at? You sneak around? Well, yeah, random spots. Like we went riding up to the store or in a car. And counsel stood here and tried to argue they let him. Did she just really say that to you? You sat here and listened to 2 hours patiently, a long audio, and not once is there a threat. She said, there's razors on the floor. Are you kidding? They're laughing it up. 98% of the time of that audio, they're just sitting back talking, casual, hanging out. Man, how'd you get rid of the body? There's laughing going on. And they come up and argue to you, again, trying to force this doubt. Folks, that's you know what to do with that. So I come to a close, talk a little bit about that Don Quay and the parsley. Listen, it's not just like the confession. You can say, well, listen, I'm going to be frank with you. One confession alone convicts him with these circumstances. Well, one of those alone is enough to prove beyond any doubt who did this. For your ears to hear a confession and get a confession from a blood brother is just that much more compelling. But think about these pills. It's not just the fact that these pills existed. They were ordered on the defendant's wife's account, and she came in here and swore under oath, and let me tell you, convincingly so. I didn't order them. Did you notice the count on these? These are 100 counts, both of them. When the detective collects them, they put every one in here. There's nowhere near 100 in these. And they're sitting at the top of the closet of the victim, IS. And they tie back to one account, the defendant and his wife's. By the way, she's pregnant at the time. You catch that? She doesn't need these. Who are they for? It's clear who they were for. Then they come up and ask you, well, you remember Barbara Johnson? She's with Gun Gallery. You don't know whose signature's on this form. Well, it says Johnathan J. Quiles. There's his signature. Yeah, but you don't know he signed it, forcing doubt on you, trying to create possible doubt. So I call Naomi Quote, Miss French and I call Naomi Mobley to the stand. We walk it up and show it to her. Is that your husband's signature? That's his signature. Why are they asking these kind of questions to you? And by the way, the whole thing about Ace and like, how does he know this property so well? How's he going to do this with all these people around? He knows it better than everyone. Why? Don't forget that map. The Lindroses say he brought us this map unsolicited. He'd only been an employee here he'd only been an employee there for about 90 days. So somewhere in the middle there, they said he brought this map, showed all the weaknesses in the fence. He's been all over the back of that property. Joseph Quiles, he took the stand and he testified, these are the things my brother told me. I said, sir, do you want to be here? No. You love your brother? Yes. I'm going to describe the brother like this. There's a quote from John Wayne's biographer, a guy named Scott Eyman, E-Y-M-A-N, and he wrote that John Wayne is this kind of a man. Quote, he had a spirit that makes firemen rush into a burning building because it's the right thing to do. End quote. Joseph Quiles did the right thing. It was the right thing to do. Joseph Quiles broke one of the strongest bonds that exists on earth. And that's a brotherhood bond. He came into a court of law and he raised his right hand and he said, this is what he told me. I couldn't stomach it, so I shot her. I had to get rid of that baby. Counsel stood right there and tried to get him to say, well, you don't believe that. You don't believe that. You bet he doesn't want to believe that. But he sure as heck picked up that telephone on January 8th of 2019, called the police. On January 8th, 2019, remember this, and calls the police. On January 10th, 2 days later, you heard the words right out of his mouth on the wire, matching what Joseph Quiles testified to. Taking the witness stand and doing the right thing. And I asked him why. I said, Mr. Quiles, I said, you tell this jury why you're doing it. He said, it's the right thing to do. We don't tolerate the use of women in our family. I wanted the police to have this information so they can go look for her and maybe bring this family peace. Joseph Quiles' testimony alone convicts him. With all these circumstances surrounding and all the evidence that surrounds that confession, that alone convicts him. Lastly, the defense just argued to you that we don't have any evidence, right? They sit over here, there's all these holes in it. Just look at your video board and look at the evidence that you've heard in this trial. I'm not going to read every one of those to you. There is a mound of evidence.
You know, Judge, screaming it louder doesn't make it true. But it is a strong closing argument. I like what he did there as well.
Yeah, absolutely. I agree. It's very strong. It's passionate. It is loud.
Yeah, it is kind of loud. All right, we'll finish up with the state's rebuttal right after the break. But we do want to let you know the jury has actually begun deliberating. They've been at it now for about, about 31 minutes or so.
And I just want to add, Tiffany Smithfield, producer, says they can either go home at 6, come back at 9 tomorrow, or they can have dinner at 6 and stay. The jury hasn't yet decided which they're going to do. We'll also bring you the state's final words when we return. Keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, an in-depth profile of the accused killer in the Delphi murder case. What we know about Richard Allen and what his defense team is now saying about the investigation. And the civil trial begins today in the case at the center of the popular Netflix documentary, Take Care of Maya. We'll bring you the biggest moments from opening statements as this trial gets underway.
Closing Arguments with Vinnie Politan, tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. We're about to hear the final part of the state's rebuttal in the pregnant niece murder trial. But we do want to let you know the jury has the case. As you know, we want to show you every minute of what goes on in that courtroom. So we're a little bit behind, and they've been deliberating now for about 35 minutes or so.
And we don't want you to miss any of the closing arguments, so let's get you back inside the courtroom for the prosecutor Daniel Skinner's final words on the case.
There's evidence overflowing here. There is evidence that will bring us to phase 2 of this trial. There is evidence that the defendant is guilty of first-degree murder of IS, Ayanna Sawyer. There is evidence that he is guilty of killing her unborn child. Proof beyond a reasonable doubt. And there is evidence we have proven beyond a reasonable doubt that sexual battery occurred on IS by the defendant. That presumption of innocence that you have done nothing but adhere to and pay attention so attentively, you can now just strip that off of them. This case is now where it belongs, and that's with the people. We talked about those 3 branches of government when we started this, the judiciary, the executive, and the legislative, but it's the people that make decisions. It's the people, you as a jury, that brings justice, which is so needed in this case. We now ask you to go back and convict him of all 3 counts, guilty as charged as to all 3, and carry us to phase 2 in this trial. On behalf of Ms. French and myself, we thank you for the last week and 4 days. Thank you, Your Honor. Nothing further.